Hello and welcome to this Deprivation of Liberty Safeguards Roundtable event to discuss reconsidering risk and responsibilities in 2023 and actions into 2024. Whilst priorities in the health and social care sector differ, we understand that whilst waiting for liberty protection safeguards to be implemented, there are a number of factors to be taken into consideration, and we're here today to discuss some of these. I'm Alex Reid, Relationship Manager at Xyla Health and Social Services. Xyla Health and Social Services and CHS Healthcare are the leading providers of managed service solutions to local authorities and ICBs across the UK. Since 2015, Xyla has supported over 45 clients with health and social care services, including Care Act assessments, occupational therapy assessments, children's services, continuing healthcare assessments, and deprivation of liberty safeguards. I'd like to invite each of the speakers to introduce themselves. Hilary, would you like to go first?
Certainly. My name is Hilary Paxton. I'm a senior advisor at the Local Government Association, working in the part of the Local Government Association called Partners in Care and Health, and that's a joint venture between ADAS and the Local Government Association. I've worked with the Liberty Protection Safeguards for the last few years. I'm currently working on other projects, but I'm still very interested in this topic area.
Thank you, Hilary. Alex, would you like to go next?
So, hello, I'm Alex Keane. I'm a barrister at 39 Essex Chambers, specialising in mental capacity law. I've also got a strong interest in policy. So I was, for instance, the consultant at the Law Commission working on what was to become the Liberty Protection Safeguards, albeit in different form. So, as I say, I straddle both practice and policy. Thank you, Alex. Kenny, would you like to go next?
Hello everyone, my name is Kenny Gibson. I'm the National Head of Safeguarding for the NHS. That includes all ages safeguardings, not only in the NHS and primary care, but independent healthcare providers with an NHS contract. I'm a mental health nurse by background and midwife, and I've always had an interest in supporting staff and colleagues to implement mental capacity assessments better and certainly provide deprivation of liberty safeguard referrals in a more timely way.
Thank you, Kenny. Francis?
Hi, I'm Francis Lyons. I'm a partner with Capstick Solicitors. I'm our national lead for Mental Capacity Act, Corporate Protection and Deprivation of Liberty work, and currently very busy with both commissioners and providers on this fraught issue of deprivation of liberty and making it authorised.
Thank you very much. It's great to have you all with us today. So throughout this roundtable, we're going to discuss how responsible bodies can address and mitigate a number of challenges, some of the legal implications and risks associated with deprivation of liberty safeguards, and also preparation for liberty protection safeguards. So I'll get started with yourself, Alex, if that's all right. It'd be great to get your view on how the impending LPS implementation, which has now been significantly delayed, how responsible bodies can best address the challenges faced in keeping the vulnerable population safe, provider services lawful, whilst also mitigating risks to responsible commissioners.
Thank you. It's a really important question. And actually, I think I'd really want to focus as much on what can we do now rather than what should we be doing in terms of preparation, because we just don't know when LPS is going to be implemented at the point of recording this. And one thing I have to say, which has really increasingly concerned me over the past few years, is that people have been actually pushing an awful lot of stuff off, going, it's all right, LPS is coming, so therefore we don't need to do X, Y, and Z. We don't need to train. We don't need to focus on specific things because LPS is coming and we can sweep it all up then. So I think and I think this has been increasingly recognised amongst different bodies as a major problem. So in terms of what people can do now, in terms of responsible bodies, whether that be health, whether that be social care, it's actually going right back to basics and going, who amongst the people we are caring for are deprived of their liberty? And that sounds like a really obvious question, but actually when you start going down and you start thinking about it, that is hundreds of thousands of people. all of those people who are confined, not able to leave, not free to leave, subject to continuous supervision and control, all of those people who can't consent, and all of those people who are confined where the state either knows or ought to know about them, which effectively means I now train on the basis that if you have complex care needs, you are very likely to be deprived of your liberty, because those needs means it's very likely that it will be not considered safe for you to leave where you are. It also means in many cases you won't have capacity to consent to what's going on. So it's kind of making sure that actually people are aware of their cohort. In some cases, it's very obvious. There are lots of people in care homes, it's very obvious. Many people, though, in supported living placements, educational placements, it makes me very concerned at the level of knowledge / lack of knowledge in educational placements about young people who are confined. People's own homes, an awful lot of situations where either health or social services are or ought to be aware that families are, for instance, locking up an older person with dementia to try and keep them safe. So it's actually just identifying you've got a cohort of people who are deprived of their liberty, and then going ahead and working out how to make sure it's actually authorised, which is just one of the reasons why LPS is so important. Is it would streamline and make really clear who has responsibility to authorise, and there's an administrative framework which can cover everything. At the moment, we've got an administrative framework which covers one very small group, actually, hospitals and care homes over 18. I mean, it's a big group, but there are hundreds of thousands of people who are not in that cohort. They're not over 18, or they're not in a care home or a hospital. So it's making clear, being very clear within the organisation, do we know who's deprived of their liberty? And if they are deprived of their liberty, what do we do about it? Do we either bang on the door of a local authority saying, hello, you're the managing authority, please can you make sure that you do whatever you can do to authorise the deprivation of liberty in a care home or hospital? Or do we need to make sure that we are taking the case to court? And one thing I would really flag up is that quite often I hear people saying, well, LPS is bringing about a big change in terms of the role of health in terms of authorising. Well, yes, it is, in the sense that health are going to be responsible for self-authorising within hospital, but there's no change at all in terms of health being responsible for bringing about authorisation in the community. That's been in the continuing healthcare framework for some considerable period of time. The most recent iteration is paragraph 346. If somebody is continuing healthcare funded, it's the ICB's responsibility to take that case to court. It's just, there's no two ways about it. There's no policy change. That's just what it is. That's what needs to be done. So to me, those are the kind of really important things. And then one of the things that you can sort of do, but being very aware that LPS is, of course, not in force, the 2019 Act is not in force, is thinking about, well, what is LPS telling us about how to think about things? And one of the big things that LPS is supposed to be telling us is you are supposed to be front-loading thinking about capacity, about confinement, about the necessity and proportionality of confinement. It's supposed to be front-loaded at the point of initial care planning, as opposed to stereotypically what happens at the moment is everyone does all the care planning and then sends in an application later to the local authority to say, by the way, all this has happened, this person's deprived of their liberty, and a local authority, managing authority for a care home goes, this person shouldn't be here, and it's all too late by then. So LPS is supposed to be making sure people are front loading, and that's already meant to be good practice. People doing things under the Care Act, people doing things under the NHS Act in terms of thinking about someone's care. You should know, is the person you're working with confined? And if they are confined, can they consent? I mean, that's just basic, I mean, I don't be rude, but that's just basic care planning. So there's that front loading aspect. And of course, the better the work which is done in terms of the initial care planning and initial documentation of the care planning, the easier it is at the moment and in the future to make the authorization process relatively painless, because it's checking that over. It's not having to go back and completely redo everything. So that's one aspect. And then I think the other two other aspects before I'm sure other people have got things they want to say. One is, and I've just got this personal bugbear, so I'm just going to bear it for a second, which is that DoLS capacity test, in other words, the test you're applying to ask whether or not someone's got capacity for purposes of deprivation of liberty safeguards, is a really weird test on the face of it, because it looks like you're only asking about, does this person have capacity to agree to be at this place to receive care and treatment, which has nothing on its face to say about, is this person actually confined? In due course, LPS will make the capacity test very statutorily clear, can this person consent to the confinement? But that's already part of the law, because we've got case law which explains if you're going to confine someone, you do need to make sure they can understand, retain, use and weigh the fact that they are being confined, which means people need to explain to them the core elements of the care plan, why you're not allowed to leave, why you're under continuous supervision and control, and get confirmation that the person can actually understand that. So that's one aspect. You could say it's LPS thinking, actually, it's already the law. And the other aspect is to really focus in on, is it really necessary that this person's confined? And is that confinement really proportionate? Rather than just saying, is it in the person's best interest? Because the law is already best interest plus necessary and proportionate. And necessity and proportionality is just so crucial. And the easiest way I think of thinking about it is there actually a risk at all? Is there any risk at all? If there's no risk, then confining the person is completely unnecessary. If there is a risk, is it actually proportionate to that risk to confine them? The other way of putting it is, are you just making the situation worse? And as Sir James Mumby routinely used to say, and I think it's a very sensible thing he used to say, what is the point in keeping someone safe if you are merely making them miserable? And that's where the proportionality aspect comes in. So to kind of, just to stock take, as it were, please, people need to be making sure that they are actually clear who within their cohort of deprived of liberty, what they're doing about it. And in terms of the assessment, in terms of thinking, it's really front loading this stuff in terms of care planning, because that's just good practice on both health and social care. And then being very clear about, can this person actually consent to what we think needs to happen? And then, is there actually a risk we're bothered about? What is that risk? And are we actually, is it worth the candle imposing this confinement on someone? And the very last thing I'll say is, always remember, deprivation of liberty is not, or the question of is someone deprived of liberty is not to be muddled up with, is this the right thing to do? Just because you're doing the right thing and you think you're supporting the person doesn't mean you're not depriving them of their liberty. It means it can be justified, but it's terribly concerning when people start saying, well, I'm trying to do the right thing, I'm trying to look after this person, therefore it's not a deprivation of liberty.
Thank you, Alex. Has anyone else got anything to say on that point?
Yes, I have a question really, which I'd be interested to see what Alex would answer. Where somebody has maybe opted to move into a care home themselves and they are in a locked unit. And so even if they are not lacking capacity to choose, they've chosen to be there, but they can't get out because they don't maybe have the ability to manage the locked unit. I've heard a lot of people talk about, unlawfully depriving people of their liberty when they didn't realise they were being deprived of their liberty. So I'm just interested to think about the interplay really between the capacity, and maybe they don't lack capacity to choose where they are, but they may not realise that they're being deprived. Is that a non-question, or is that something that people maybe need to understand when social services are then asked to come in because somebody's needs may have changed and they may have to do some care planning at that point when they're already in that unit?
Well, in a way, I would say that's exactly why the DoLS capacity question as it stands is a bit weird, because it looks like it's only asking about, does this person have capacity to decide to agree to go into the care home to receive care? Whereas actually what it needs to be asking, and the LDV case, which is the case which kind of brought in the additional aspect, makes it clear that the person, you do need to stress test, does the person know? So in other words, have they actually been told that they are confined? So what are the core elements of that confinement? It's not like they need to memorize their care plan. They need to know, we just don't think it's safe for you to leave. And this is why, and if you do, this is what we're going to do. So the person needs to know that. And then the stress testing needs to be, Can the person understand that? Can they retain that information? Can they use and weigh that information? If they can they communicate the decision that, yes, I'm content with it? And you may well get people who are actually content with that, because they might go, I'm worried about my safety. I know I might do something. Actually, I don't mind, but I'd be quite nervous about making that assumption. And I'd be particularly nervous about doing it without actually having informed the person. And I was just reading something the other day in relation to cultures where cultures which don't like telling older people that they've got diagnosis of illness, because it's extremely important not to distress the person. There's a similar feeling here. Well, we don't want to distress them by making clear X, Y, and Z. Well, okay, that's fine at one level, but actually what you're doing is you're not really being honest about what's going on, and you're not getting the chance to say, is this person confined or not? And the really obvious thing to say is every time CQC comes round, any provider should be able to say to CQC, this is the basis on which this person is here. They are here genuinely of their own free will and actually capacitously. And even if it looks like they're confined, they're fully signed up to it, or they're not. And this is what we've got in place to make sure that this deprivation of liberty is actually properly checked off. I mean, that's one way I sometimes find of helping people kind of concentrate people's minds. At which point you quite often see, when you've done the training there, people on the hospital ward. This most often happens, I have to say, in mental health hospitals. And you suddenly see the ward manager racing off to have discussions because they realise, actually, all those patients we've got who are allegedly informal mental health patients, I'm not 100% sure I'm really confident I could give a straight answer to CQC at this point.
I can jump in on the back of that, actually, with a practical example of a mental health unit. So this was about a decade ago, I should say. And the key thing is what Alex mentioned in his earlier explanation about the ability to consent to confinement. So there was a patient who was admitted under the Mental Health Act, no recourse to public funds, but lawfully resident in the UK, was then discharged from section, but had literally nowhere to go to, so wasn't discharged from the hospital, remained on the locked ward, but by consent. And the local authorities and the health commissioners dilly-dallied about who was going to take responsibility, where they were going to go to live, etc. And then after several months, unsurprisingly, a judicial review and a claim was brought on the basis of inaction and a need for discharge because the person was entitled to Section 117 aftercare, regardless of not having recourse to public funds. And it had to be settled because there was no clear evidence that anything had been explained to the patient about their care pathway, or that they'd been asked about whether or not they understood about the confinement they were experiencing, and if they did, whether they consented to it. It was basically, this is the best place for them because there's nowhere else to go. And doubling down on Alex's point, well, okay, fine, you're doing the right thing, potentially, but actually, have you asked the patient and do they agree to be here? And that ended up getting settled out of court for problems that I would hope nowadays could easily be avoided by actually having a patent conversation with the patient about what their circumstances are and whether they actually agree, and that would see off any censure by the CQC or any damages award, because a capacitous patient can be demonstrated to have consented to the arrangements which are in place. So yeah, there are real stings in the tail for not getting it right here.
It'd be great, Francis, to hear a bit more about some of the legal implications with, deprivation of liberty. If you could touch a bit more upon that.
Yeah, sure. What Alex has covered the key points, I think, about the Deprivation of Liberty Safeguards scheme. So I would double down by saying that I think, and I optimistically believe, that that's actually quite well understood in terms of what needs to be done for patients and individuals who are in care homes and hospitals. The obligation primarily is on the people running those organisations to make sure that they apply for an authorisation from the local authority as a supervisory body. The complexities start getting introduced in relation to people to whom that statutory scheme doesn't apply. So that's people under 18 who might be in a care home, hospital, or other institution, where there's no consent, or those in the community. And again, Alex has talked about people living at home or in supported living, or perhaps in shared life schemes, or other new and developing placements, where the statutory deprivation of liberty safeguard scheme simply doesn't touch them. It can't. So your only option then is to apply to the court for an authorization to make it legal. And there's a real tension here, and particularly picking up on something Alex said earlier about hospitals and actually trying to do the right thing, but actually not having the authorization. So a real thing we're seeing coming through at the moment, and have done for about 6 months now, is underage patients being brought to A&E either under Section 136 or just simply by the local authority because parents can't cope at home or a placement is broken down. And the acute hospital are taking them because there is literally nowhere else for them to go. And the local authorities are frantically trying to find somewhere. But the hospital isn't the best place for them. The hospital ends up having to consider making an application to deprive them of their liberty to a ward or to A&E because there's no bed to admit them to. But actually, they don't want an order that they be deprived of their liberty in hospital. What everybody wants is an order that they go somewhere else and be deprived of their liberty. But in the interim, there's a reluctance to apply for the order. There's a well-known shortage of Tier 4 beds, secure accommodation, and registered placements for young people. And what do you do in the interim? And the courts have been consistently clear that the local authority or the hospital has to apply. It's unlawful to keep them in hospital without authorization. The parents can't consent if they're over 16. And then the question moves on to where do they go to? And it's probably a topic for another day on which we could each spend another hour talking. But unregistered placements, getting the court to actually authorize someone going to somewhere that's not registered to look after a child. But in the interim, the court can offer that support and authorization. And those are the short-term difficulties in a hospital. Moving on, Alex has spoken about the clarity within the continuing healthcare framework on the responsibility of ICBs to seek authorization for those that are CHC funded. And it's been in there for a while, but it's not just limited to CHC funding, of course. If there's Section 117 funding in place, those individuals are being funded with a package of care that potentially deprives them of their liberty, and it's attributable to the state, whether or not you're jointly funding between local authority and the ICB. One of those organisations needs to take the lead. And the same position is true with just general joint funding. Somebody's got to apply, and I would strongly recommend anybody listening to this not to think that the other state authority is going to do it, because that way someone falls between two stools and there's no review in place. And so for those adults who are in the community, perhaps in supported living arrangements, the only way to bring the matter within the law is to get a court authorization. There's help at hand, and I suspect that those listening will know of or will have heard of the COP DoL11 process, which is whereby applications can be made where there's no dispute. But sometimes there will be a dispute. And so then you've actually got to bring a mainstream application to the Court of Protection. And there are a number of issues with that because there isn't legal aid available automatically for those people who are being deprived of their liberty against their will in a community setting. So organisations need to be really organised. They need to work out who it is that's likely to be deprived of their liberty, get the applications into court as early as they possibly can, because by doing that, they offer the patient an opportunity to get legal aid before the substance of the application gets going. Otherwise, local authorities and ICBs face requests, which the court are going to have a great deal of sympathy for, to not only pay their own lawyers to get the application going, but also to provide cost assurance to the patient's lawyers so that they can be represented whilst the funding position for them is sorted out. And frankly, there's limited choice for commissioners in getting that underway, because without that representation, you can't really move forward with the application. And the danger of not going forward with that application is that fundamentally someone's being deprived of their liberty without protection. There is no review, and you're depriving them of their liberty unlawfully, which I'm hogging the limelight a bit here, but that leads me on to some other legal implications, which are that the providers could end up getting fined. The commissioners or the providers themselves could be subject to remedy awards and criticisms by the public Parliamentary and Health Service Ombudsman. And worse still, from a legal point of view, you could get damages claims been brought for breaches of the Mental Capacity Act and the Human Rights Act. Now, individually, if someone is in the right place, those sums might not amount to a lot, but we're seeing increasing awards being made against providers with increasing amounts of damages. So there was a recent case against an acute hospital where tens of thousands of pounds was awarded for a fundamental breach of the patient's rights. They weren't properly assessed for capacity, there wasn't proper planning on their best interests, and the family weren't consulted, and they weren't moved into the right place of care for some months. So there's a legal monetary hit in your pocket, but also then there's the wider ramifications for the residents and patient population that you're serving. What confidence do they then have in the commissioners of their care and in the providers who are helping them with that care? And where the onus is on the commissioner to secure the authorization, if you're not doing that, I worry about the effect on the provider market, because people might be nervous to come in because they're doing the depriving of the liberty. And if there's going to be damages claimed, then they might be swept up within that as well. So that there are significant ramifications for that. And then I think probably my final thing to say at this stage is this future-proofing point that Alex has talked about. There are hundreds of thousands of patients out there, looking at the NHS side of things, who aren't authorised. I suspect there are more on the local authority side whose packages haven't been properly scrutinised in order to work out whether there is likely to be a deprivation of liberty going there. And there has been, in my experience, a trend to kick this down the road, because the introduction of LPS would wave a magic wand and suddenly it'd be really easy to do all this work. It ain't. The same assessments and the same scrutiny have to be applied. And you can be doing it now and saving yourself an even bigger mountain of work to be doing when the LPS kicks in, by actually looking at these packages of care, getting an idea of who needs to be authorised now and what the volumes are. Because if you're struggling with the manpower now to put this through, I think it may well only get worse when the LPS bites, unless you're actively assessing your numbers and actively thinking in conjunction with the other stakeholders, what volumes you're dealing with and how you're going to manage those. Because if you don't, you're creating a bigger problem down the track. So that's a rather pessimistic note to sort of be concluding my main spiel about the legal implications on. But I think it's very true. If you don't get on with it today and next week, that when the LPS does come in, you've got a much bigger number to worry about.
I agree, and I think it breeds practice. So as if you're not doing that, if you're not getting into those good habits, then that is influencing practice of people who are coming up and training to work in this field. And so there's a real risk that if the lawyers and the social workers or the social care assessors within a local authority aren't seeing that happen, they don't realise that they need to be looking out for it. And it's about good practice breeds good practice, and we all learn from each other. So that then means that there are the same legal implications for a wider range of people than there would be if we were moving into better practice.
Yes, I think that's right. And also, in a purely practical function, we need people within the commissioning organisations now to be taking these steps to familiarise themselves with all the principles. Because if those more senior think that suddenly when the LPS comes out, they're going to get it magically because there's a new regime in place, they won't. They need that learning and they need that experience now, as well as it being the right thing to do for patients now.
Can I just jump in there and say I completely agree. And also, the single best training that you can do in terms of LPS is to make a community deprivation liberty application, because actually it is doing all the things that you are doing in terms of an LPS application. It's just going to a court. It's not going to somebody within a responsible body. And it's the organisations I've seen who have really kind of grasped that as an idea have really found, yes, it's quite painful to start with because we're just having to try and get our heads around how we think about these things. But actually, once you get your head around, apart from anything else, this starts showing that we can then work out, well, where do we need to be better at front loading stuff care planning wise, and where do we need to be better at doing certain, and thinking about people's capacity. And those are just, I remember when I was at the Law Commission, the entire point of this exercise was not to generate paperwork. The entire point of this exercise was to try and think about how can we do things so that, well, A, minimize paperwork, but B, try and ensure that actually decisions are taken at the earliest possible stage about capacity, or assessments at the earliest possible stage about capacity, about best interest, about necessity and proportionality, so that wherever possible, actually you can avoid things happening. The person doesn't need to go into the care home, the person doesn't need to be moved. But if they do need to be moved, then at least we've thought through very carefully why that's the right thing. So I'm at the risk of my repeating myself, this goes back, this is just fundamentally about good delivery of care, with DoL, deprivation of liberty, as certainly the icing on the cake, but it's the thing which follows on secondarily from that.
Thank you, colleagues, for your reflections on the legal implications. I'm going to bring hope to this, because you've each recognised from a legal perspective that the bulk of the NHS colleagues, and there's 1.8 million of us, have the privilege of wearing an NHS lanyard. We are making progress towards including consent and capacity assessment when we have an intervention. And it isn't only about hospitals. Deprivation of Liberty Safeguards is explicitly about inpatients. So what about outpatients? What about outreach? What about the new modern way of delivering acute care in the community? So organisations, acute organisations, NHS trusts who will become responsible bodies under the LPS, they need to look and make every contact count, we call it, in clinical practice. And you know something, I'm built upon hope. And what I'd encourage us all to talk about, as well as the legal implications, yes, that is a corporate responsibility and executive accountability in the new integrated care boards. There is an organisation at the side of that called the Integrated Care Partnerships, where local authorities and voluntary sector and care sector and primary care, they must all come together and solve these conundrums that are for every person that sees the NHS, and there are millions of them each day. And what I'd be hopeful for is looking at what the LPS code is going to bring is that moment of consent, that moment of capacity assessment will perhaps limit confinement, but will be a journey. Because I know as a nurse that very few patients who go as outpatient departments wouldn't have a nugget of capacity assessment in their GP practice. Whilst they're having their vaccinations or whilst they're seeing their GP for the referral into an outpatient appointment, the GP makes themselves familiar about capacity and consent for that intervention. So our intention is to blend it into an ongoing assessment, as we do with neurologically diverse conditions, as we do with child safeguarding, to be a bit more cognizant that mental capacity assessment is at times fluctuating at home, and therefore it needs to be part of an assessment journey, whether you're a district nurse or whether you're a GP, whether you're a receptionist or whether you're a podiatrist. That moment when you see someone's inability to consent to treatment must be logged in your clinical record, but that requires the policy to have a minimum data set and information standards notice as part of any guidance. Otherwise, you can't count, you can't audit. And it's back to your point, gentlemen. I think there is no greater moment in the development of integrated care, whether it's a board, whether it's a system, or whether it's a partnership, to support these great thinkers and commissioners of all ages continuing care, as well as NHS continuing care, or any citizen. We've got to be able to count in order to project forward what the scope and scale of consenting for capacity is going to be, and it is not going to diminish. Neurologically diverse conditions, autism, etc., all the vulnerabilities tell us that the number of citizens with the need for capacity assessments will increase, and so therefore we need to have an auditability process. I'm also looking at the legal implications rather than scare the bahookie out of my colleagues, why don't we, as Hilary says, learn from excellence? So why don't we, from a legal context, yes, remind implications of cost and suing, etc., whatever the litigious process is. There's also our duty to not only bring hope that we can do this, but our hope that we can learn from each other's excellence. So where there is a shining example in health and social care, we should be using that and celebrating it as that making every contact count between our collaborative providers. So we have a moment in time that we must face the provider collaboratives, not individual providers. We must face primary care networks, not individual GPs, and we must face the partnership, not only the integrated care board. So I'm hopeful that we can learn from the LPS journey, because we certainly need to sustain the journey we're having with mental capacity assessments.
Can I say, I totally agree with you, Kenny, and having worked in different, sort of both across health and social care, roaming, well, mostly from my shed during the pandemic, thinking about this, it is really interesting and really actually genuinely inspiring to see those organisations who have gone, right, we can either look at this as an enormous pain and an enormous bureaucratic hassle, and we just would really like it to go away, or we can look at this as an opportunity to audit what we're doing. And if we're not getting it quite right, think about it. And actually, where we are getting it right, roll that out. And it's been really interesting seeing across a whole series of different organisations, both health and social care, and including also, I'd actually emphasise, in some situations, children's services, where previously they're not actually having to think, they didn't really think they had to think about this, and they've suddenly realised, oh my gosh, they do. It's really interesting then people saying, right, well, how do we do this so we can roll this stuff out? So it's actually doing things like ramping up our basic, the core basic principles of thinking about capacity, thinking about best interest. So yes, I try and be hopeful as well. And but it is really interesting. I mean, one of the kind of only upsides of this incredibly long delayed process is that you do have a number of organizations who haven't done, well, we're just going to sit around and wait. We're actually going to try and get ahead, and we're trying to think. And it's been really interesting and as I say, inspirational watching people actually go, how can we do this well? And then it's a question of how people like you were able to shout that from the rooftops, for other colleagues.
Yeah. And that doing things well must be done as a collective. We cannot afford part of the system or a responsible body to go streets ahead and leave everyone behind them. We've got to move together. It's a call to action moment. So as an example of that moving together, we took 42 health system leaders into something we call a clinical reference group, and we reviewed the suggested LPS data set by looking at the code, by looking at the assessments, and we've come to conclude that all but 6 data points are already captured within the NHS clinical record system. So it's going to take very little to go into that world of NHS with 1.8 million people and umpteen providers and 42 new ICBs and say to them, look, if you increase your information standards notice by 8 data points, you will have achieved the analytical review of an LPS assessment. So it's trying to bring solutions and hopefulness in this world in order to avoid legal implications. And we're very well placed in the NHS to do that, because we've had a unified approach to data, we've got a singular approach to counting, and we've got the analytical tools, and we've got to focus on that analysis and data to build something fit for 2023 or 2024, whenever LPS comes, but we need it now.
Can I just say something on the about care homes as well? Because obviously within the NHS now we're talking mostly about hospitals or continuing healthcare commissioned services. In terms of care homes and in terms of people who fund their own care, it may be that neither CHC nor the local authority have had any involvement in their caring, their care planning or their assessment of needs yet. And the onus is really on care homes, therefore, to recognise where somebody may lack capacity and what needs to happen, and also if there is a deprivation of liberty. I came across a care home only this week who told me that they'd never spoken to an advocate before. So they were wanting to find out how somebody paid for chiropody in the care home because they'd been placed in the care home, and they rang the advocate. And then the advocate was saying, well, you know, you need to speak to the people that are organising the care. The advocacy service is independent. It doesn't actually get involved in arranging the care. And the person in the care home was saying, oh, well, I wasn't quite sure what the role of an advocate was. So that's quite interesting, because there are still care homes out there who might be providing a lot of care, really good service and good support, but who are not experienced in DoLS and may not know that they should be raising the application with the local authority. And so in terms of the implications for individuals and safeguarding individuals, those people may be deprived of their liberty, but they may not be getting the safeguards that are offered by the DoLS scheme because nobody's picked up on the fact that it needs. So in terms of waiting lists, those care homes that do understand about DoLS and have applied, the risk then is that the waiting lists mean that they have made an application 6 months ago, 9 months ago, and nothing's happened. And there's a risk that they therefore won't bother next time because they've waited so long for this. So then that person isn't getting the safeguards that would be afforded, and forward-thinking care homes will be putting and people that have been inspected by CQC will be putting the applications in because they'll be reminded that they need to do so. So at least the care home have been thinking about it, thinking about capacity and so on, and thinking about the confinement, as Alex was talking about. And they will be thinking, I mean, it's been interesting with COVID really, because there was a big hoo-ha in the first lockdown about blanket DNA CPRs, and although the change in practice was brought about reasonably swiftly, a side effect of that was that it made people think about the capacity element and the do not attempt resuscitation, cardiopulmonary resuscitation. You know, the fact that you have to work out whether the person can consent themselves, and whether they have the capacity to do that, and if not, you have to consult someone else, and you know it's all built in to the DNA CPR. So when Kenny was talking about GPs, for example, they have got some of their experience because of COVID, because that initial approach which said, oh, we need to put blanket DNA CPRs, and then it was changed. It meant that all the GPs were perhaps forced into thinking about capacity, thinking about rights, and thinking about applications of the Mental Capacity Act that they might not have been if we hadn't had the COVID pandemic. So it's funny how some of these sort of things that may start out as a bad thing can actually help with the learning and safeguard people in the longer term, so that they haven't had you know, assumptions made about them. I mean, that's not just about DoLS, but it means that the context, what we're trying to do while we're waiting for LPS, is make sure that people at least understand the Mental Capacity Act 5 principles and understand you know, where it needs to come into their practice. So that includes care homes and primary care and so on. And so I think there's a lot of scope for us to do work both in children's services and in adult services, even where DoLS is not relevant, to bring everybody's practice up to scratch on the Mental Capacity Act, and that in itself will help safeguard people better, because once it is recognised that there's a deprivation of liberty, they won't have to go through all the capacity learning, because they'll have that.
I couldn't agree more, Hilary. I think what we mustn't do to have a call to action that making every contact count needs for healthcare patients or care homes, citizens or placements is make whilst we need to together bring a degree of legal literacy and understanding to everyone that comes in contact with a patient, a citizen, a client, a resident, whatever they would wish to be called in that context. We're not trying to make legal experts of them. You know, I'm always dumbfounded about the amount of people, including executives, that want to become legal people. No, that's what the lawyers are for. That's what your legal advisors are for. But we must absolutely have the principles of mental capacity inherent in every contact. And, you know, a higher level of understanding deprivation of liberty decisions in the clinicians. So we're working on this, for instance, through our standard setup, which are the Royal College of the Royal Colleges, whether it's psychiatry, whether it's emergency medicine, nursing, the Royal Colleges are really beginning to understand everyone needs to know something. And a higher level of that needs to know about how to make decisions, and a higher level of that needs to be executively accountable and know what the implications are. So I think it's about time that we share this type of awareness and decision making, because in my world, whilst the person's in a care home as a resident, they do come in contact with an NHS GP. They will visit an NHS dentist. They may even go to an A&E department. So, you know, we are all, the vast majority of our citizens are NHS patients. It just so happens what their residential placement is at any time is that conundrum about who does the mental capacity and deprivation of liberties. But technically, they're all utilising NHS services.
Thanks, Kenny. Alex, do you want to jump in?
Yeah, and actually, I think Kenny made a really multiple very important points, but the one really important point, just as it were, being one of the lawyers on the call, is I think sometimes people can get terribly afraid of the law, partly possibly because of the way in which the lawyers frame it. And it's how one can internalize that. I mean, I was trying to do actually trying to work on some guidance with NHS England about a difficult issue. And I was trying to start out the very first paragraph being, it would be very rare that the law and your professional ethics are ever going to be out of alignment. So in other words, it's not the law trying to provide something to beat people about the head. What the law is supposed to be doing is saying, this is the framework within which you operate and exercise your professional judgment. We are all actually trying to do the same thing. We're just using slightly different language. And part of that, it comes down to on the kind of core principles of the Mental Capacity Act side. And I think it's, you know, so often actually you would find if you really went in and followed people around, like a wonderful academic called Rosie Harding did, following people supporting individuals with learning disability around, she actually was able to tell them after the event, you do realise what you were doing was supporting decision-making capacity. You were thinking about it, you were supporting it, and actually when you couldn't support the person to make the decision, you were making a best interest decision. But this was all, some of that was all at really micro level. It was at things like what colour t-shirt to wear, what food to have, that kind of stuff. And actually, when she was able to explain to them, you realise that's what you were doing. You were applying the Mental Capacity Act. The support workers went, oh gosh, wow. Then they were able to go, well, actually, how can I skill that up to think about, I can make a bigger decision, I can work with a bigger decision. So I think some of it is about training, or sort of how people actually explain this is what we're doing and why we're doing it. And I think to me, one of the sadnesses is that sometimes it does get difficult to explain, and this is one of the bits which is difficult to explain, is that the bit I said right at the beginning, or nearly at the beginning, that deprivation of liberty, and it's partly the language of deprivation of liberty, people get very stressed about the idea that they're being told off and they're doing something wrong. And family members get terribly upset at thinking, you know, why is my loved one like that? Or actually, I put it just as much with people in the caring professions thinking, I don't want to be depriving this person of their liberty. And the definition that the courts have given us is a very broad definition, which really doesn't take into account in deciding is the person deprived of liberty, whether or not the person is, as it were, happy with the situation. If they can't consent, there is a deprivation of liberty. There needs to be a check and a balance. So part of it is always thinking about ways in which to explain actually what you're doing isn't necessarily wrong. We just need to make sure there's another pair of eyes on it. And to me, that's one of the important linguistic changes. Even when liberty protection safeguards, you know, when it finally arrives, it will lose the word deprivation. because that's, you know, just in terms of trying to align, this is what the law is saying we need to do, and this is what good practice is, healthcare practice, good care practice. It makes it less jarring. Whilst, of course, recognising there are some situations where what is going on is completely against the person's will. And then we need to tease out very carefully, why are you doing that? Is it really justified? But it doesn't mean, at least it means in a much greater majority of cases, we're not having a continual jarring, kind of frightening aspect.
Yes, as the National Head of Safeguarding representing the NHS, I spend my life bearing witness to legal jargon and trying to create a contemporaneous cohesive narrative across the range of practitioners and carers that we've all got to inspire to do the right thing. And you can tell by my language, I'm a mental health nurse. It's about common language and cohesion and common understanding, particularly from the lived experience. And let us not forget that in our world of healthcare, sometimes there are other practitioners telling us to restrain, telling us to restrict. An example I use time and time again since coming into this job is where police will tell us to restrain someone to avoid them leaving the A&E department, lest they become a missing persons and have a police welfare visit. So, you know, there are moments when trauma-informed practitioners from justice system or the policing or community safety partnerships, they have a different narrative about how to control someone leaving a hospital ground because they're fed up waiting, or B, they just want to be out. And so, yeah, there are loads of practitioners to satisfy, including our trauma-informed policing colleagues, that sometimes we've got to have that common narrative, and it must all face the lived experience. It must all relate to the person who we're trying to prevent harm to or prevent safeguarding moments to. So it's increasingly common that let's group around common narrative, but let's face it towards how it feels to the person at the centre of this.
Shall I leap in as my hand is up? Thank you. I just wanted to bring together the points I think that Alex and Kenny have been speaking about the key central role I think that education has here. So in some of the training I provided to clients on COP-DOL11 processes, using that as an example, there has been some genuine nervousness on the basis that I can't do this, I'm not a lawyer. But the thing that I would say about the COP-DOL11 and the court protection generally, it's the least lawyerly part of the whole court system. And the COP-DOL11 form itself, although it's a mouthful and it's got some big frightening expressions like deprivation of liberty in it, actually all of the information that you're putting in there are things that are within the daily experience of health and social care professionals. Very, very little of it is actually legal. The big kind of umbrella question is this person being deprived of their liberty? You don't need to be a lawyer to understand that. And in fact, as a health and social care professional, you'll probably have a better understanding than the lawyer looking at that form of whether or not that person is actually deprived of their liberty, because it's all about what are the restrictions in the package of care. And as a health and social care professional, you will understand that better. So I'm really keen that people don't think that this process is something that lawyers do. We can absolutely help, but actually this is something that ought to be being considered by everybody. And the risk is, and Kenny, you touched on it, with the police telling you you've got to do things, looking at it in a slightly different way. Actually, when professionals come to then speak to the families, if they're coming at it with the mindset that it's something I've got to do because the lawyers are making me, it kind of misses the point that this is central and fundamental to the patient's rights. We want to do the right thing by the patient. And this is part of learning about what the circumstances of the patient are and what they would want. And we need you, the family, to feed into that. Whereas I worry that sometimes the narrative is that someone doing an assessment is going out to the family apologetically saying, I'm really sorry, but we need to speak to you about this and we need your, inverted commas, permission. And then the family feel defensive, as Alex spoken to this point. that they're doing something wrong because permission needs to be sought from a court, and that's not what it's about. It's about empowering the patient to make sure there's a review and the best package of care is put in place. And the way to doing that, I think, is driving out that information. But I think I'm probably being far too optimistic here to think that we're going to get the entire population educated in this. But it starts with health and social care professionals properly understanding and then approaching colleagues and families and patients in the right way about it, so that they're not creating fear or concern at the get-go.
Yeah.
I just wanted to concur with that, Francis, as well as making every contact count in clinical practice. Reachable, teachable moments, we call them. I think we've also got an opportunity to reach out and just be working together, have a unified script around this, don't we? Whether you're a receptionist, a clinician, a social worker, or anyone that works in health and social care, it's that moment that we just inspire them. This is about you. And, you know, we're all in this together. But I think, if I'm honest with you, either for responsible bodies, the legal interpretation, etc., that's an overarching anxiety that we need to rebalance, as Alex has said and Hillary's pointed out and yourself has said. You know, this is happening every day. This is probably happening every hour of every healthcare provider's life, if not every intervention. We ask what colour of t-shirt do you want to wear? But people don't see it as that legal journey, because you know, many of us have become obsessed with a referral, which, you know, it's a complicated document to fill in, but it's a process. It's a trusting relationship activity that we all do because we care. No one comes to work to break the law. And I think we've got to go on a journey with everyone and say, look, that moment, you made it happen. It was a reachable, teachable moment, and you made it happen. And celebrate it and be proud of it, that you were implementing mental capacity. I don't think there's enough of that.
Some great comments from you. Go on, Alex.
Yeah, so I just said I will never forget the case that a local authority brought, which I just thought was wonderful, to bring a case on behalf of someone to get a declaration that the person had got capacity to make decisions about contact with family members because she just didn't want to see them. And I just thought that was talk about doing something empowering. I just thought that was a really striking, put your money where your mouth is.
I think it'd be really good to hear. Obviously, it sounds like there's a lot of things that can be done in the run up to LPS, you know, from both a respect of making sure that we're prepared, but also dealing with the here and now. And some of that is training, you know, it's making sure that everyone is aware of all of these different legislations, but, you know, not just from a lawyerly perspective. So Hilary, I know the ADAS Spring survey that was published last year identified that 64% of directors weren't confident that their budget would meet the duties associated with DoLS. How's that going to impact in the run up to LPS and with dealing with those, you know, those people that are out there that unfortunately don't have a DoLS in place or are being unlawfully deprived?
Yeah, it's a difficult issue, this, because there's no two ways about it. The number of applications did increase dramatically some years ago, following the Cheshire West judgment. When the Liberty Protection Safeguards programme was going through Parliament, the Mental Capacity Amendment Act bill, as it was then, was going through Parliament, there was a lot of occasions when they used the term 125,000 cases in the waiting list that were, you know, at the time, that were not safeguarded because they were in a waiting list instead of having gone into an equivalent DoLS process. And I looked at the figures just to see where we are with the state of the waiting list in terms of the director's legal obligations or statutory duties. It did actually increase after that. It went up to the end of March 2019, it went up to 131,000, but it has gradually come down. And I think the pandemic we don't quite understand the impact of the pandemic on the figures, because quite a few people passed away in the early days of the pandemic that might have needed a deprivation of liberty safeguards authorisation. But at the same time, because people couldn't see people face to face, quite a lot of short authorisations were granted. So that meant that the number of DoLS authorisations was higher, because they might have a 3-month authorisation that was then renewed for another 3 months and another 3 months. So the number of deaths that might have reduced the total number was balanced out with the number of shorter authorisations. So it went down, and in March 21 there were only 119,500 waiting. That's not how many applications there were, that's how many were waiting to be completed at the end on the 31st of March. And it's gone up to last March to 122,000. So we're running at, until we get the data for March 2023, the current estimate isn't an awful lot lower than the estimate was when the bill was going through Parliament in 2018 and 19. What worries me a little bit more is the proportion of those in that waiting list. Obviously, some of them, they're just they've only just applied in the March, so some of them may be processed very quickly and may be completed in the April. So that's a snapshot as at the end of March, and includes applications that have just been made, but it also includes applications that have been made any other time. And what really concerns me is the proportion of applications that have been waiting for more than a year. And it's worth saying that back in that first period when the bill was going through Parliament in 2018-19, 38.6% of them had been waited more than a year. And we're now at 35% of them waiting more than a year. So what that means is either a hospital or a care home have applied for DoLS authorisation. They may have put an urgent authorisation in place, and they're applying for the standard authorisation. And then the authorisation is not completed in longer than a year. So that's obviously an average over the whole country. And what I would say is that some councils have been able, certainly prior to the pandemic, they were able to really make inroads into their waiting list, and people who were, they were able to get the numbers right down. And then they went back up again during the pandemic because of other difficulties. Other councils just haven't been in a position to be able to do that. So it feels like we're kind of a little bit better than we were when the bill was going through, but not better enough. So it seems like there are councils, a small number of councils, who've got more than 1,000 cases waiting for more than a year. And then there are other councils that don't have a waiting list, small, short waiting list, but not. So it really is a wide, a broad church, if you like, of councils. So when the ADAS surveys are done, they're looking at that whole range of them, and there have been further surveys done since the one that you referred to, which is looking at other types of assessments that aren't happening, and there are I'm just looking for my information here, that the ADAS carried out a count in April 2022 through its members, and it was looking at all types of assessments, looking at direct payments assessments, social care annual reviews, and care and support work. And 540,000 people were waiting for a completion of their assessment at that time in April 2022 when they ran it. And that was an increase of 30-odd% from five months earlier when they'd done a similar count. So the context of DoLS, I'm afraid the work that's being done to process DoLS, which is all done in the local authority, unlike the Court of Protection cases, where the assessments are done by either social services or the NHS in the continuing healthcare function. The staff that need to do the work are also being called to do work on needs assessments, on care planning, and various other things. And there is this is not an excuse, but there is a broad understanding that there is still an adult social care crisis and that there's a workforce issue. Skills for Care have published in October to say that there were 165,000 vacancies in adult social care. And that was a 52% increase on the previous year. So some of those vacancies are in provider services, but we also have shortages of social workers to do the day-to-day work. So when directors are asked about their confidence, what they're having to do is they're having to think about prioritising all of their statutory duties, of which DoLS is only one. And the question that was specifically about DoLS was one of a number of questions that was asked at that time. So ADAS and the Local Government Association, ADAS is the Association of all the Directors of Adult Social Services, do talk to government, talk to other partner stakeholder agencies at a national level about how can we work on the workforce strategy to make sure we can attract more people into the field. And that's an ongoing task, and you will be aware that the government made additional funding available for adult social care, but there are still fears about insufficient investment in adult social care. And so, you know, the representations continue about more funding for and more attracting more staff into the field, so that there are more people to do the work. So in the reality, I think that one of the biggest issues is the lack of a firm implementation timetable for LPS, because I know that there were some councils that had project leads and steering groups and people set up to look at the implementation of LPS and how that would go. And because of the recent delays in the decision on when the timetable will work, some of that work has been stood down. So in terms of the preparation for the Liberty Safeguards, that's kind of on pause. And the difficulty is if the staff that were championing liberty protection safeguards were also championing the Mental Capacity Act and getting it right now, that means there's less attention on all of that. So I really would hope that we will soon have an announcement about the timetable, because at least that will be able to give us a framework within which to plan and to do some of the education that my colleagues on this roundtable have been talking about, because it will give us a focus to think about, okay, well, what is the training that people need and what, you know, who needs what and that sort of thing. Whereas at the moment, I think it's kind of been put on one side. DoLS hasn't been put on one side, and as I say, some councils have managed to make great inroads, but it's an ongoing challenge in the current context. And there is a risk then that, because frontline social workers tend not to get as involved unless they're also a best interest assessor, they tend not to get involved in DoLS, and the risk with that is that they're less exposed to mental capacity considerations, and as Alex has clearly articulated, we need people to be thinking about this in every interaction with somebody who may lack capacity. They need to be thinking about that routinely, rather than thinking it's only when DoLS is around. So DoLS sort of encourages people to think about that, and LPS will be brought right into the front line, and everybody who's a social worker will have to be thinking about LPS rather than specialist BIAs. So that will encourage everybody to be working with the Mental Capacity Act every day. So I think that the sooner we can get LPS in, the better for safeguarding people, but it needs to be planned and prepared for very carefully.
Well, I think Kenny go first, then me. Kenny's going to say something more cheerful than I will, I suspect.
Oh, maybe more hopeful than cheerful, but I think we do need to recognise that local authority colleagues are rising to the challenge and processing and converting deprivation of liberty safeguard referrals in a timely way. But yes, there is still delay, and that has an impact on providers in itself. And particularly a motivational impact,
Yes,
because if there's an increasing number of DoLS unresponded to or declined or not converted, busy, hectic clinicians do get into a mindset of why bother? We're continuously about this. If my referral isn't responded to, then do I do the next one? But we know where the sort of delay pressures are. We know the specific local authorities because there's an authentic honesty now. There's a common language and a common understanding around where these delays and why these delays are there. And again, I would face forwards to the Integrated Care Partnership to discuss a collaborative approach to funding, resourcing, delays and deferrals of deprivation of liberty safeguards, because we need to get to that minimal point where things are up to speed before you implement a new process. And I think we've also got to look on that new LPS process whenever it is launched with a very clear steer to our government colleagues. If you bring in a new mandate on local authorities, or particularly in the NHS, we're expecting 18 months of an implementation transition period. Change like this, welcome as it is, does not happen overnight, because the ICBs will become responsible bodies, but they're currently responsible bodies for mental capacity under NHS continuing healthcare anyway. But they do need a moment in time, maybe a year, 18 months, to stand up the technology, to stand up the data, to stand up the portals that will allow them to analyse and count this type of new information. And let us not forget that ICBs, in their evolution, they already have another 148 statutory executive accountabilities to get to grips with over the next year. So my role is to say, absolutely, on behalf of the NHS and behalf of ICBs, we welcome this new statutory function. However, it is part of a growing number placed upon the shoulders of ICBs, and the NHS, 1.8 million people working in hospitals, primary care, trusts, community services, domiciliary care as well, and in ICBs and NHS continuing healthcare, we expect, as we do with all safeguarding programmes of work, a period no less than 18 months, when there must be additional investment shared with local authorities, shared across the partnerships. So we expect an investment to transform the system if you expect us to implement a new process of liberty protection safeguards. So that is our position, to work with local government and say we can work together at front-loading the learning, front-loading the training together, and integrated care partnerships are certainly that product. But we've also got to give our responsible bodies, integrated care boards and NHS continuing healthcare that reports to them, an 18-month transition period just to get things right across the whole of England. Otherwise, we'll have people way ahead and people struggling to catch up.
Thanks, Kenny. Alex?
Yeah, so I mean, a couple of things. The first is that it is just hugely problematic that we have a situation where care homes and hospitals are trying to do the right thing, putting in applications, and local authorities are simply not capable of responding. I mean, Hillary's explained how there are pockets where people were able to do it, but the average length of time for the last year when stats are available is 153 days to actually complete an authorization, which is a long way beyond 21 days. And the second you go beyond, although 21 days, rather 14 days even for an urgent authorization renewed, sorry, the second you're beyond those 14 days, two things happen. One, the hospital or care home have actually got no legal authority to hold the person. So they're having to go, what do we do? How do we break the law least badly? Do we deprive this person of their liberty, or do we let them go? I mean, framed like that, it's normally fairly obvious what the answer is, but it's really uncomfortable. It's really wrong that health bodies are in that position and care homes are in that position where they're trying to do the right thing. The second, of course, is that the person who's at the heart of it doesn't have any sensible rights. They don't actually have the ability to get legal aid to say I shouldn't be here, or non-means tested legal aid. The big irony is if you're authorised, you get the chance to test for free. If it's unlawful, you don't get the chance to test for free, which is just really problematic. So I think I'm wearing my hat as the former special advisor to the Joint Committee on Human Rights when they did their inquiry into human rights and care settings. Their report is really powerful on how many people are stuck. And it's what's really frustrating is that they're stuck in situations where people are trying to do their best, and there is just a massive gap in rights protection. The other very last thing I'll just say, or other thing I will just say is, and actually, Kenny, you reminded me of it when you were talking about hospital settings. I will just put into the chat function. This was produced by the Faculty of Intensive Care Medicine midway through the pandemic because local authorities were being, I don't quite know what the right word is, pestered or plagued was slightly the perception by people putting in applications from acute hospitals which were completely unnecessary, because there is this carve out. If you're getting immediately necessary life-sustaining physical health treatment, it's under the same conditions you would be getting it if you had capacity. The mere fact you don't have capacity doesn't automatically mean the person in the ICU or the person getting that high level of clinical care is automatically deprived of their liberty. And so that guidance note was put out by the Faculty of Intensive Care Medicine, and it's really blunt. It's saying this is what deprivation of liberty looks like in this setting. If it's a deprivation of liberty, please make an application. If not, please don't, because you're just wasting everyone's time. And so part of it is thinking about how to make sure that people know in that healthcare setting, that specific healthcare setting, when actually they shouldn't be putting one in, and shouldn't be putting one in, as it were, just to cover themselves. Because every time you put one in just to cover yourself, a local authority admin person is having to think about it, and a local authority person is having to think about it. By the time they've actually had the chance to think about it, it's extremely likely the person's either recovered or died. So there's been a kind of waste of time there. So just to go back to the theme of what we do whilst we wait, there are some things where some organizations need to really take a really long, hard look and say, actually, do we have a proper protocol in place to think that are the patients we're caring for actually, are we thinking about deprivation of liberty, or are we actually not thinking about deprivation of liberty? We're thinking about capacity and best interest in relation to care. And so that can alleviate some, but not all of the pressure. But it's very striking when you look at the stats, the DoLS stats, the number of uncompleted references coming in, applications coming in from acute hospitals is very, very high. And that's because quite a few of them probably didn't need to be made, and they're just ones which local authorities shouldn't be having to run around trying to deal with. So I rather wish, in a way, we'd been able to have the conversation with the joyous middle section in terms of the education aspects, because this has got really gloomy again, but hopefully at least it's gloomy but clear-headed.
Thanks, Alex. Francis?
Thanks. So I've raised my hand just to pick up on some points that Hilary and Kenny made, but just touching on what Alex has said and the that guidance from the intensive care medicine faculty. Our out-of-hours emergency line is bombarded with exactly these sorts of calls from the acute sector because there's a lack of understanding about when they need to go and what they need to go for. On the positive side, we're very happy to help and that they're actually thinking about it, at least, even if we then warn them off. I just wanted to pick up on some of the stats. So we've talked about the delays, obviously, in relation to the statutory safeguards scheme. This week, I've had 3 emails from the Court of Protection asking for updating evidence on community DoLS applications, because the care plan that was lodged is a year old. That's not that unusual, because sometimes you put in one which is a few months old at the date of application. But these are on ones that were contemporaneous, and the application is over a year old. So even for community DoLS applications, the Court of Protection is in no better place, I think, than the local authorities in terms of authorisation. So that's taking a long time to come through. The other slightly gloomy point I wanted to raise on the stats in response to what Hilary was talking to about the numbers is the fact that there was a pause in CHC teams being able to do their job during the pandemic. They were told to down tools and were redeployed to other, arguably more urgent roles. And a lot of patients were moved around the system. We had discharge to assess funding. And it's my experience that some of those teams now are still trying to work out who is where, who's paying for what and what those packages actually look like. So I think we're going to see a tail still coming through on some of those applications being made. In the hope, though, of introducing some optimism in light of Alex's comment, Kenny and Hilary, you've both spoken to the fact that people are kind of doing the DoLS work as adjuncts to doing the needs assessments and their other roles. But I think where we need to get to is a point that I think we were all agreed on earlier on in the discussions, which is that actually these aren't two distinct things. The obvious solution to my mind, particularly in health, is if you're doing a CHC assessment or an annual review of any sort for funding and assessment of needs and reviews, embed that DoLS consideration within that process. That we haven't got two tracks ploughing on in parallel, neither speaking to the other. It's the same people doing the same thing, or at least those doing the assessments being equipped to know who in their organisation they need to speak to because they've got to worry there is a DoLS, rather than that DoLS person having to mysteriously alight on that particular package. If everybody knows about this, then it could be done as one, and I think that'd be really useful, and it would lighten the load.
Which is what LPS is introducing, which is, when it comes, there will be some efficiencies. Sorry, Kenny, I jumped in.
No, I think we're Mr. and Mrs. Mental capacity, aren't we, Hilary? We're certainly of the same opinion. I couldn't agree more. We have to blend this into all our practice, and it goes back to, because that's what the person at the centre of this assessment needs to have. It needs to be a positive, affirming experience. Not I ask you these questions and then I ask you these questions again, and then, by the way, you're in a different room, so I'm going to ask you the questions again. And I would urge us all to remember that those interventions as a journey should actually be welcomed as a digital enabled health and social care passport. Those moments in time when we have a contact with a dentist, when we might have a contact with a GP or the community pharmacy or the social worker, we should be able to record our capacity assessment as well as someone in certain, for people with neurologically diverse conditions and learning disabilities particularly, they have the electronic version of their health action plan. Why can't we begin talking about the future of capacity being part of our summary care record? Every one of us is allowed to download our GP assessment of us on the GP from the GP system. Why isn't that coded for how I believe my capacity to make best decisions is now, so that perhaps when I need lasting power of attorney or when I need fluctuating capacity, because it can happen at any age. This isn't simply about elderly people going to a care home. This is about any one of us. So I'm a great believer in digital enabling this, because I own my digital electronic record, not talking about deprivation of liberty as being a paper referral, whether it's emailed or not the LPS being 9 different assessments on paper that we've got to share by snail mail. But let's rise to the challenge as system leaders and recommend integrated care partnerships adopt this mental capacity now, but let it be digital enabled. Because you know something, that makes the experience slicker. It makes it my information, not your clinical data. But more importantly, it allows the ICB to count. It allows the integrated care partnership to have a cohesive number base, not data. And thank you for the data, Hilary, but it's already 16 months old. And it doesn't make projections. So we got to look back at data at what the pressures are, but we must project forward to realise what the scale of mental capacity needs. And it must definitely be digital enabled, and it must almost certainly be analytical or with an analyst rather than counting through forms, would be my proposition.
Thanks, Kenny. I think that's a really good point. If I can use this as an opportunity to sort of wrap everything up, I think it's been a really helpful discussion, to hear from everyone's different standpoints, from everyone's backgrounds. And I hope that this has been beneficial for everybody that is watching this. And thank you very much to each and every one of you as speakers today. So if anyone's got any questions for any of the speakers, please feel free to get in touch with us. Our email address is info@xylahealthsocial.com, and we'll pass it on to the speakers to get in touch with you. So thank you very much, everyone, for your time.